Hey everyone, Harry here to talk about the Supreme Court's declining to lift the gag order in the New York case before Judge Merchan where Trump was convicted. Plenty of things to point out here. The first is, even though the court, I think, can be counted on in certain instances to really rule for Trump, the immunity case is the best example, and it was a really consequential and I think ill-fated ruling. We shouldn't think of them the way we think of, say, the cabinet he's assembling as 9 or 6 justices in his pocket. They see themselves as bigger than him. They mainly don't like and don't respect him, but there will be many times where he will proffer principles, really wild-eyed ones that no former court would have embraced, like immunity, that they will come through for him. But they are a very, very important kind of force on the board as you think about what Trump 2.0 holds for us, but we should understand the perceived limits of their role. And so today, to Trump's great chagrin and disappointment, the Supreme Court issues orders blandly, as it will after conference, that simply says the lawsuit that Trump filed to try to invalidate the gag order that Justice Merchan in the New York case imposed on him is unconstitutional. It's gotten nowhere in the federal courts, and it shouldn't get anywhere. And now the U.S. Supreme Court has said, we're not going to look at that issue, meaning the issue is dead, meaning the gag order remains in place. Okay, let's just review the bidding a little. So he's in trial, and he's talking all kinds of trash, threatening to Merchan's daughter, whom he's using to try to attack Merchan because she works for a PR agency, basically, that does a lot of work for Democratic candidates. So he's saying for that reason, Merchan should recuse himself, and Merchan continually rebuffs that very kind of tenuous and stupid claim, but Trump, continues to beat the drums on it in the press. And then, importantly, this is an aspect that the press coverage hasn't cottoned on to, and it really matters. The order extends to certain things that are important while the trial was pending. For example, he can't insult not just court personnel, but anyone on the jury, etc. So when it ended, that needed to be revised. And at the time, both the original version and the revised version, Trump tried to suggest was some kind of deep infringement of his First Amendment rights, that somehow the insulting of the judge and the things that were barred by the gag order was down the middle political speech and central to his campaign, which is, of course, now over, and that could be one reason to influence the Supreme Court. But it never was, importantly, that was always completely not just overstated, but deceptive. And then besides that, as I've pointed out again and again, the gag order, though Trump, to make it analyzed according to basic First Amendment principles, as if it were the state simply telling Trump, here's what you can talk about and here's what you can't. It's actually a whole different rubric, a whole different category, which is the power of the state or federal government to assure the integrity of their trial proceedings. And you can't talk trash about attorneys or jurors, not because there's some First Amendment limitation, but because there's a whole different interest that doesn't even run through the First Amendment, that is about you can't sully the actual process itself. Okay, so anyway, that's the point when it was first done, but then the trial ends. And you might have thought that the gag order would simply end. The trial was over, can't really mess with the jury anymore, etc. But Mayor Chun, within his rights, said, no, I'm going to reform this. I'm going to take off elements that no longer make sense once the trial's over. But this gag order still remains in place because this case is still with me, and all kinds of things could happen, including the overturning of the conviction, as Trump has tried to do, not this most recent time where he's now moved the court to make the case go away, but the time before that he said, I get a new trial because the prosecution introduced Hope Hicks' testimony, and that ran afoul of the immunity principle. So Mayor Chun is thinking maybe he wins that, it comes back down, and it falls to Bragg to decide whether to retry Trump, and he does. Well, that case, in a real sense, has never left the purview of Justice Mayor Chun. And that means that Mayor Chun is within his rights, the same kind of rights I identified in explaining the basis for the gag order, in saying you can't just talk trash in a way that could not scare individual jurors, they're gone, but either harass individual spouses or court employees. Talk all you want about me, but don't talk trash about the bailiffs or my clerks or whatever. Then second, the process itself. You can't pollute the jury pool, and you're still possibly going to be tried here. And that is part of what's involved when Trump goes and tries to dissolve this whole gag order. So to me, it's an important principle. And when I say principle, people make the mistake all the time of seeing a Supreme Court denial of cert as a statement on the merits. It isn't. It has no precedential value. They're just saying, in our discretion, we're not going to listen to this. Nevertheless, what it suggests, and the failure of the whole claim going up, is the system as a whole has approved of the notion that Trump, president to be and soon, remains in the clutches of the New York criminal justice system. So, for example, if Mayor Chun imposes some kind of probation based on the convictions here, or just generally says, you want to travel? You better ask me first. Things like that are legit, or so would appear. In his new motion, Trump may well try to challenge the whole thing based on newfangled principles or extension of what the Supreme Court has said about immunity. But failing that, what we've learned basically from, even though it's non-precedential, from today's order and the general failure of Trump's motion, is that president or not, he's been convicted, and he remains in some ways within the control of the New York trial level court. And, he's going to have to say pretty please to do certain things as long as that remains the state of affairs. So it's all wrapped up. It's true in the broader gauge claim. He's trying to make the whole thing go away. But for now, it's a very useful reminder that absent some intervention like that, Trump is like anyone else who's been convicted, has some impingements on his liberty because he's before the court, and the court can do things to ensure the integrity of the trial process, including Trump showing up and conditions of release and the like. It's all part and parcel. So that, I think, is an important and unidentified aspect, unidentified in the press materials that have covered this point to date. So a good thing to add. But basically, the gag order remains, and absent a broad holding in the other motion to dismiss that he's bringing, Trump is like other convicts. That's what he is. in some measure can be within the grips of, and have to say pretty pleased to, the court that is overseeing his ongoing action. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.